everyone, welcome to my YouTube channel, Yasumi Tech YouTube channel. So today I'll be covering the legal perspectives related to artificial intelligence. So for that, I'm getting Vibhav Mithal. He's an AI and IPR lawyer, associate partner at Anand, also fellow and law for Humanity Group, and also he's working for the MKI Group. And a rising star 2022 and 2023 for managing intellectual property. And those are a few things about Mithal. So he's joining today to give you a basic understanding and to cover the basics of legal perspective of AI.
Hi, how are you?
I'm doing good. How are you?
All well. Finally, we managed to connect,
Fine.
and I'm so glad. Yeah.
Yeah, thank you. Actually, I also had a couple of tight schedules, and you also had the same.
Yes. Yes.
Yeah. So, shall we start?
Sure. Sure. Absolutely. We can start.
Okay. So I know that you are an AI and IPR lawyer, associate partner, fellow in AI and law, and also managing intellectual property, a rising star as well to 2022, 2023, and much
Yes.
more.
Right.
So I would like to give you the opportunity to introduce yourself about your background, how you entered this field of AI as an IPR lawyer, and all those things.
Absolutely. It's an absolute pleasure to be here. My name is Vibhav Mithal. I am an intellectual property rights lawyer, specifically an intellectual property rights litigator. I also advise clients, but I represent clients in court. In addition to intellectual property, I also practice in the area of artificial intelligence and data protection laws. And I'm looking at the field of AI from a non technical legal lens. And I'm looking at AI as AI, very similar to intellectual property rights, which are patents, copyrights, and trademarks. And if you understand the concept and then you see it around you, for example, you could see a shirt that you're wearing could be protected as a trademark, or the design of a shoe that you're wearing could be protected as a design, or the drug that you may take, a medicine that you may take when you're not well, could be protected by patents. And just very similar how concepts of intellectual property become visible to you when you learn the concept. My interest in AI, or my expansion of my field from intellectual property rights to AI as a whole, not only an extension of legal practice to AI, has also extended to AI in the same way, which is that when you understand what is artificial intelligence, you see it around you. You see it when you're, say, watching a movie on a streaming platform. You see it when you are going on social media and you like certain things, and so it becomes omnipresent. And it's this very broad level of similarity between learning between intellectual property rights and artificial intelligence that I got interested in this field. And now I pursue this in many roles, some of which that you have described. And of course, I can, just to list them, I can say that I'm a partner at one of the leading law firms in India called Anand and Anand, where I practice IP law. In addition to that, the voluntary roles is I'm a fellow in AI and law at For Humanity US, which is looking at audit frameworks. And at For Humanity, in addition to helping For Humanity with their audit frameworks, I am co-lead of Team India. So we're developing an AI audit framework for India. Even though this idea or demand is still a little far off, we're doing that. I am also an associate fellow at Center for Responsible AI at IIT Madras. IIT Madras is one of the leading technical institutions in India, and the Center for Responsible AI is looking for research on responsible and ethical AI. And there are a couple of other roles that I also play. One is with Extended Reality Safety Initiative, which is in the space of emerging technologies, with MKAI, where I now just guide the conversation on a WhatsApp group. And I also serve on the peer review board of a journal, AI and Ethics. The short point really being using my legal lens and looking at AI from multiple dimensions. So it's a pleasure to be here. Thank you.
Yeah, so I also went through your profile, very detailed information about you there. I'm happy to connect with you like a person who's working for different global organizations trying to make an impact for AI. And in your introduction, you also told that we hear about AI, artificial intelligence, but we can you explain it in a way, easy way, non-technical way, everyone can understand how we differentiate from generative AI? And you also use that word, that non-technical term. So yeah, my audience will.
Absolutely. Absolutely. It's my pleasure. So, at a very simple level, artificial intelligence is, and the one line answer to it, it is a pattern recognition tool. And let me explain that further. Artificial intelligence is a manner in which a system is trained on large amounts of data, and then the system would identify patterns from that data to reach the desired output. Let me give you an example, very simple example. For example, I am trying to develop an AI model that helps identify a cat. For that, I will obviously need to create a data set or collect data on the images of a cat. So what would we do is we would have a data set. Let's simplify this. Let's say we have only 10 images. Though of course you may need far more than 10 images to train an AI model. But for the sake of understanding AI, let's take an example of 10 images. So we have 10 images. One is of a cat, one is of a horse, a mouse, a rabbit, a dog, and various other animals. Now, what I do to train an AI model is that I would label the image of the cat as cat, but the image of all the animals that are not cat, for example, such as horse, rabbit, dog, I would label it as not cat. What I'm doing here is that I'm labeling my data by giving it cat and not cat distinction. And within this aspect, I am labeling both the input data, and by doing this labeling process, I am also indicating my desired output, which is a picture of horse is not a cat. I don't want the model to recognize this. This process of labeling this and then using this data to train an AI model to figure out what is an image of a cat and what is not an image of a cat. This concept, very simplistic, this is a concept known of supervised learning. And so you're training an AI model, and you are helping it detect patterns. Now, what actually happens is that a model is trained on large amounts of data, and after being trained on large amounts of data in something known as the AI black box, it figures out the patterns, and it helps re- reach this point of identifying a cat, because that is what it is being trained to do. This entire training process of also, first is the data element. So there's this element of collection of data and the right amount of data that you may need. And in the example that I used, there's this aspect of labeling the data as cat and not cat. And then this training the AI model, and then the AI model, I'm not getting into too much technical jargon, but the training model would it eventually, what happens is the data gets converted into 1001 sort of numbers, which then the AI model figures out how to figure out the patterns. But this entire process is are done it requires a little bit of technical skill by machine learning engineers. and they train an AI model in this manner, and that ends up giving you an output, say, of a cat or not cat. So, but if again to come back to the original description of how I explained AI, it is a pattern recognition tool training on large amounts of data, and it helps you identify a pattern from that data. And how it is different from generative AI, that is a traditional AI model, right? It will detect patterns from an existing data set. How a generative AI is slightly different in terms of output, right? uh, to take our continuing our example, a normal AI model will tell me whether it is a cat or not a cat. A generative AI model, on the other hand, while detecting patterns, will also help create an image of a cat, right? So a generative AI and AI is different in the sense that the output of a generative AI system could be a text, could be an image, could be a video. Where the output is a text, it is now known what is now known as large language models. For example, ChatGPT or any other models that might exist. On the other hand, when there is the output of an AI system, say maybe an image or a video, image, for example, there's stable diffusion, there's mid journey, and both of these have certain legal implications because they've also have some these tools have been used even in some disputes. So there's mid journey and stable diffusion. When you have these kind of tools that are generating an image output, in the legal, I mean, in a technical sense, they're known as large multimodal models. So LMMs and LLMs, large language models, large multimodal models. And so that's the difference. And so an AI system would help figure out whether it's a cat or not. A generative AI system would tell us whether it generates an image of a cat.
Understood. So let's move on to another question about the challenges. So AI is rapidly transforming many industries, but its legal implications are still being read out. What are some of the key legal challenges that arise when it comes to artificial intelligence?
It's an excellent question. So I think AI is fairly broad, and I think the way to understand the legal questions that may arise allows us to look at a very broad concept called AI ethics. And of course, ethics may appear to be very abstract, fungible, and I mean, it's perhaps incomprehensible for being a very broad concept. But to identify the legal issues of AI, the reason I start with AI ethics is it's perhaps the biggest umbrella. If we understand the concept of AI ethics or the different facets of AI ethics, do we come to the legal elements, right? And AI ethics has to understand AI ethics. There are two ways in which it can be understood. The first way is to look at AI development, just as I explained earlier about how a AI model might be trained. There might be, at the time of training of an AI model, there might be certain ethical choices developers may make, right? For example, when I'm collecting the data set, what kind of data I may be relevant, what kind of data may not be relevant, may be dictated by ethical choices of those developing an AI algorithm. In that scenario, those ethical choices influencing the development of an algorithm and those ethical choices that are made is one facet of AI ethics. And this is slightly less understood as the concept of AI ethics because these are ethical choices that you have made during the design and development of an AI algorithm. That is one aspect of AI ethics, and these ethical choices then therefore can lead to certain legal issues that may arise. For example, if in the ethical choices there is a certain type of data that I may have left out, and that may lead to the data set not being representative. And with the data not being representative by leaving out certain data, which might could be an ethical choice, right? Wrong is to be decided subsequently. That could lead to issues of bias. And issues of bias could be a matter of exclusion. For example, in hiring decisions, it could favor one particular population over the other. If a particular AI model is developed, is AI model is being used, say for example, to decide whether a particular criminal will reoffend or not, a biased AI output could, by a biased AI system, could give biased results. It could, for example, person A may be able to reoffend, will be reoffending, but the AI model would say no, the person may not reoffend. Or on the other hand, the person may not reoffend, but the AI model would say no, this person will offend again. And that could be a result of the biased data set. For example, this is an actual case of the compass or algorithm used in Florida, where a biased output would resulted in a AI model saying that a particular race could reoffend when they did not, and on the other hand, it favored one race over the other. So this is connecting into ethical choice and the concept of bias, how we've connected to a legal issue. Another way of perhaps looking at AI ethics is what society demands from AI developers, or from AI systems, or from how an AI system is developed, whether it be developers, company, everyone in the entire chain. And this could then have multiple lenses, right? There could be the issues of privacy, which is taking your consent before developing and training an AI system. There could be the issue of manipulation and exploitation of vulnerable users. For example, there was this very famous doll. I'm talking about an example 3, 4, 5 years ago, perhaps, which was used. It had an embedded AI system. It was being used by children, and the children would speak to the doll, and it was an AI recognition sort of a tool which would then record those children conversations, and it had those certain elements of sort of non-disclosure of it being an AI tool. And so there's that element of AI being used with children as a children's toy. There could also be use of algorithms, and all of these will get to legal issues, right? Then there's the aspect, for example, if you have a social media platform and you use algorithms to filter out content. Now, in which context, what kind of filtering mechanisms have you used to train that? So has a social media platform used to censor out content? Is that training, for example, if the training may have been used in the Western Hemisphere, and that training mechanism is used perhaps on this eastern side of the globe, on the Southeast Asian region, is the training from the Western Hemisphere contextual enough for it to be used effectively on this side of the globe, right? So these are the different types of issues that arise. There could be issues of bias, I've already mentioned. There could be issues of security. Are your AI systems secure enough or not? So, and which could lead to issues of hacking and breach. So there are multiple, when we look at AI and law, it's a fairly broad landscape, and you could have issues of privacy, you could have issues of perhaps interaction with children, you could have issues of bias, you could have issues of filtering mechanisms in social media examples. And now with generative AI, you could also have, of course, you could also have issues of intellectual property rights. Issues of intellectual property rights even existed before generative AI came into the picture, but we also now, but they've sort of taken a different turn after the advent of generative AI, and IPR could come up as a separate issue. And you could also have issues of creating echo chambers, right, with social media filtering your content and AI being used. So that's a very I guess that's a fairly long answer, but the point is there are diverse legal issues that may arise, and it really depends upon the context in which AI is being used and the kind of people that are being impacted. And the reason why AI and law has to be understood from the prism of AI ethics is because ethics and AI ethics sets us at an ideal standpoint of what we may be expecting from AI, or how, what kind of ethical choices need to be made when you're developing an AI system. And when we start from that broad umbrella, are we able to delineate and identify specific legal issues in the different contexts in which they may arise?
Thank you, Vibhav. So, another question I have is India is a major player in the field of AI, but its approach to regulation is still evolving. While there is no single law dedicated to AI, the government has issued guidelines for responsible development. So, can you elaborate on the current state of AI regulations in India? Since you are also from India, you're the best person I should ask this question. And what future considerations are being made, particularly regarding balancing the innovation with mitigating risks and all?
Right. No, thank you. That's an also a very topical question, because see, AI regulation. So we, of course, so the only law that is purely looking at AI globally, at least, much like the GDPR, is the EU AI Act. In the Indian context, we've had a fair number of soft law principles. And when I say soft law principles, what I mean by that is they are voluntary guidance. There are not legally binding obligations. There are two laws that are predominantly currently being invoked for AI. One is, of course, the recently passed, or well, not recently passed, but earlier last year was passed, is the Digital Personal Data Protection Law, which protects personal data. And just we highlighted earlier in the conversation the importance of personal data or data while training an AI system. There's the Digital Personal Data Protection Act, which protects your personal data, and there's an overlap of that with AI, and that law lays down certain obligations on entities that are processing and collecting your data. And it will obviously also, for the common citizens who are known as data principals, there are certain rights that that law provides. So to the extent that that law overlaps with AI systems, that is one law that will touch upon AI systems. That's one. Two, we have something known as the Information Technology Act, which was perhaps enacted in the year 2000. It talks about in the computer ecosystem, and it talks about, it applies in the digital realm. In that and in that law, there are a certain set of rules the government is framed, which are known as the IT rules of 2021. I'm not getting into the full name, but a abbreviated name, which is the Information IT Rules 2021. That rule provides an obligation about on intermediaries. Intermediaries, perhaps the audience would understand, would, for example, would be an intermediary could be a platform like YouTube, an intermediary could be a platform like Facebook, any of your social media websites, which is basically a hosting platform where users upload, host content, and the company involved therein is not directly involved in the uploading and hosting of content. It is just, in a way, uh, if called upon by law, expected to monitor that content in some way. So these IT rules of 2021 are about intermediaries, and they talk about what intermediaries are to tell their users. So for example, if say YouTube or any other platform that you may use is an intermediary, and I am using that platform, I'm uploading something on, say, YouTube or on a social media platform, then in that scenario, the user agreement, or the agreement that when I use that particular service, I am to be told as a user, as a common user, some of the things that I can or cannot do. That particular provision has been invoked, is being used currently to talk about AI, to talk about AI harms, and the to educate users about the harms and do's and don'ts of AI. Now, just as we discussed the various ethical issues of AI, such as manipulation and exploitation of vulnerable users like children, or we spoke about privacy, or we can speak about bias, or we may speak about explainability. There are many facets to AI which perhaps may not be currently covered in the Digital Personal Data Protection Act or the IT rules of 2021. So, to give a macro picture, we also have certain soft law principles, and there are a multiple one of them, but I'll highlight a few key ones. There is the principles of responsible AI, which have been framed by the government's think tank, which outline certain key principles, such as principles of safety and reliability, which is that AI systems should be deployed reliably with sufficient safeguards, and so there's safety of stakeholders. There's the principle of equality, principle of inclusivity and non-discrimination, which is principle that you obviously treat everyone equally under the same circumstances. You should not have bias. Then there's the principle of privacy. Of course, it's a broad based principle. We could perhaps say that the Digital Personal Data Protection Act is, in one sense, implementing this principle of privacy in a particular hard law. Then we have the principle of transparency, which is basically that the design and functioning of AI system is getting recorded and it is subject perhaps to external audit and scrutiny. Then we have the principle of accountability, which is the different stakeholders that are involved in the design, development, and decommissioning of an AI system are responsible for their actions. Then we have also have the principle where, of human values, which is protecting the humans involved in the mechanism. So these principles of responsible AI, these seven principles that are in, have been stated by the government of India way back in 2021, are a very macro picture of how we look at AI, right? And then we also have had various other papers, for example, on facial recognition tools, which implement some of these principles. When we also have a telecommunication engineering standard, which is published by one of the departments of the government of India, which lays down a bias and a fairness standard. We also have another entity called the Telecom Regulatory Authority of India, TRAI, which published a paper in terms of perhaps spoke about a risk classification very similar to EU, which classified AI systems on the basis of risk and then said that high risk systems could be perhaps placed under a legally binding obligation. Of course, principles of responsible AI, the TRI paper, the EEC standard, all of these are not legally binding obligations. We have to see whether many of these suggestions are actually incorporated in legally binding obligations, which are actual laws that people have to comply with. But why it is important to highlight some of these things when we're talking about the AI regulation landscape in India, according to me, I think to say that there is nothing in India, that it's zero, is perhaps sort of a misconception, because if you're working in this space, there is, and if you're looking to do it in responsible AI perspective, especially if you're looking to do business in the EU, where the EU AI Act may come in, or you're looking to do business in the US, or you may be looking to do business within India, there is there are macro principles that are identified for you to build your AI system. And it is advisable that when you are developing these AI systems, you do take the necessary type of guidance in terms of what could be the actionable point, the governance point for you as someone using an AI, developing an AI system, what you could do in the Indian context, especially as these concepts do exist. Right. So I think that that's the landscape in India. Yes, there aren't some legally binding obligations, but definitely some guidance around the macro picture.
Yeah, understood, Vibhav. Thank you for the great and in detail explanation. So with AI, I'm asking a following question to that. So with the rules and regulations, I have we are coming across intellectual property. So with AI increasingly generating, creating content, the question of authorship becomes complex. So and when humans play a role in guiding and training models, as you told, in the AI systems, how should intellectual property rights be determined for the resulting creations and stuff?
So that, again, that's a very, very topical question, and a very sort of like the landscape in IP has changed after generative AI. So thank you for that. I think one step before, as I move to answering that question, I would like to, for your audience, outline what we would say. If you're looking, so there are two elements, right? There is the IP rights on an AI system itself, which is the protection rights if you're involved in an AI system, and the other aspect is perhaps the IP challenges that are emerging out of AI outcomes or AI outputs. I would like to address the first part also, and very quickly, right? Which is that if we understand AI systems in general, and this is our own articulation about, if you're trying to look at IP rights in an AI system, there could be five components to an AI system, right? There could be the hardware element, which is predominantly the chips the semiconductor chips that are powering that AI system and helps in training an AI system. And those some of the chips are made in one part of the globe. There's America getting into it, China getting into it, and of course India has also laid out a very ambitious plan earlier this year in terms of trying to build three semiconductor chip plants within India, two in the western region, one in the perhaps in the northeastern region. So there's the element of chips, and we've actually had a case in the US where a Chinese individual was for trade secrets. Trade secrets is a type of IP which is kept, secret, confidential, and breach of confidence. And there's been an arrest in California in early March regarding a particular individual who was stealing trade secrets from a renowned company. And so, in the context of chips, that's just an intersection of hardware and AI, where IP aspects have come in, which is a trade secret theft of AI chips, right? So that's one element of AI and AI systems, which is powering and the IP rights that you may get on chips. The second component of an AI system, and these two are interconnected, is the algorithm itself. Just as I explained earlier in the conversation, you're training an AI system on data, and the AI system on its own is figuring out the pattern, right? And that pattern could be, perhaps that could be an algorithm, right? And or and then there's the algorithm, and then there's the software in which that algorithm may be embedded. For example, you could have a non AI system, and you could perhaps embed within it an AI sensor. And so the non AI component could be operating by a software, and then you could have an embedded AI algorithm in it. So these two elements, which is algorithm or the software in which the algorithm may be embedded. And in both scenarios, we're touching on a different type of IP, right, which is known as patents, right? And so algorithms, there are certain nuances. I won't get into the nuances, but you may get protection for an algorithm through patent law. You could get protection of software also through patent law. And in India, we did this case called the Faridalani case, which sort of gives guidance. There's the Faridalani case, the Open TV case. There are a couple of cases that have happened in India which give guidance on how softwares are protected under patent laws. Then we have the training data set itself. The training data set, that going back to our earlier example about how a cat, how you're building a system to identify a cat and you're creating a data set. In the very example that we used about labeling a cat and what is not a cat, that is an example of supervised learning. And you create that data set. That data set could be a database in a supervised learning mechanism, limited protection. And I'm only talking about only one type of training an AI system, which could be protected by a database under copyright law. But then raw data, and say perhaps something that does not qualify as a supervised learning mechanism, there are other techniques. So there are other techniques that are used to train an AI system that may not come under copyright law. Uh, Raw data will not come under copyright law. Then it becomes a situation of how do you protect a training data set? Copyright law in some instance, but you could perhaps protect them through trade secret mechanisms. So we've covered patents covering copyright, trade secrets. So you have these different mechanisms when you're protecting an AI system by itself. Now we move to a certain level of complexity, which is AI outcomes. Now when you have AI outcomes or AI outputs, that's where a lot of these debates have happened, right? So there are two components of outcomes. One is outcomes, if do you get any copyright protection or do you get any IPR protection in the AI output, right? So there are two questions that will come in: ownership on the output, and assuming the ownership question is resolved, the infringement aspect. Let me address both of them. Let's talk about the ownership of the output. In the ownership of output, again, like we just discussed about different types of IP, ownership of output could fall within the patent space, hypothetically. In the patent space, on the ownership of an AI output, we've had a scenario where we've had a series of cases where we've had the Dabus cases, right? The Dabus cases was a scenario where you had a particular AI system that had created an invention, and it was being argued that that particular AI could be given legal personality to be given credit for that invention. But in multiple cases happening around the globe, in the US, EU, UK, South Africa, Australia, Well, South Africa was different, but predominantly the AI was not recognized as a legal person and was not given legal personality, and the output created by an AI system or the invention created by the AI system was not given the legal due recognition in terms of patent law. That's patent. Let's look at copyright law. Copyright law is protecting creative expression, right? So now there are two approaches in there's bifurcation here in copyright law as well. The US. So let me explain. So we have a generative AI tool, right? So a generative AI tool, what do we do? People could enter text in, say, a mid journey tool. I spoke about mid journey and stable diffusion. So let's come back and contextualize it in the in the legal context. There's a tool called mid journey where you may enter text to generate an image, right? You put a text and you could generate images. Now someone in the US created a comic book. That comic book had two components, right? The first component was where the human input was involved and a lot of selection, coordination, arrangement to set up that comic book and design that comic book. A part of that comic book used AI created images using the tool Midjourney. The person initially got copyright protection over the entire comic book, including the AI images. Then that person, as it turns out, put up a social media post saying that they got received this copyright protection and that some of the images in the comic book were generated by AI. The US copyright issued asked for a clarification. In that clarification, the portions that were protected that were created by the human in the selection, coordination, and arrangement, the copyright protection to protect the the, the creation of the human was retained. But to the extent the images were generated by the AI tool, by Midjourney, copyright copyrightability on that was refused. And the reason for refusal was that the US Copyright Office examined the manner in which the tool was operating, and the conclusion that it came to was that it said that when you enter the prompts in the AI tool, the manner in which the AI tool was generating its output was random in nature, because you would enter a prompt, it would generate four images, then you could choose another set of four images, and therefore the connection between the human prompt and the output that was being created by Midjourney was not sufficient enough to meet the requirements of copyright law, and therefore the US held that the use of Midjourney tool in that particular case was not sufficient to give copyright protection. So an AI generated work, even though the human had entered inputs in it, was not given copyright protection, right? And of course there was a subsequent clarification that came in which said that so what that effectively does is that if you use the tool which is AI generated, you are not getting, as a human being, if I'm using an AI tool to generate creative works, I'm not getting copyright protection on it, I'm not getting protection on it as per law. However, the US Copyright Office then subsequently clarified that that was only the analysis in that case, and it was only meant for that particular tool in their analysis of that tool. So copyright was not given in US. But on this copyright protection of AI generated work, China went the other way. China, in a particular case, basically again in the same scenario, but not the mid journey tool, but the tool called stable diffusion. So this copyright case decision in the US came around in March 2023 or April 2023. This is now happening in November 2023. 6 months later in China, someone used a stable diffusion tool to enter prompts, and basically, as per whatever the requirements under Chinese law were, the Chinese court found that the interesting point was in the mid journey tool we spoke about a situation where entering the prompt creating images randomly, which is why the human input was not sufficient to give copyright protection. In the Chinese case, the major difference was, according to the court, The individual who was entering and using the AI generative tool did not use the existing pre-existing images. They used specific prompts in the AI tool to reach the output that they were looking at, right? So the effort of the human in fine tuning the prompts, in designing the prompts, was so much to create the output of the AI system that the Chinese court said this use of an AI tool and AI generated work qualifies for copyright protection. Interestingly, the copyright in the Chinese court also, they gave it to the human. They did not talk about AI being a natural person. But the difference between the American case and the Chinese case was the fact that in the Chinese case, the human involvement in designing the prompts to reach the AI output was more, and therefore copyright could be given. In the Indian context, we have a concept of computer generated work, and it recognizes a natural person. There was a case regarding a painting app where, but in that case, there was co-authorship. A human and an AI system jointly were recognized as was initially recognized as co-authors, but because AI as a cannot be recognized as a legal person, that case then got withdrawn. So we don't have any precedence in terms of copyrightability of an AI generated work in India, right? So that's the position of US, China, and India, which is now evolving. And on the other hand, infringement, I won't get into too much detail, but in just in terms of statistics, we did a study and we found that there were about 43 cases in multiple countries that are arising around generative AI. And the IPR concerns around there are predominantly with respect to how the AI output, when it is generated, it reflects infringement of certain rights of creators. So when I look at and I analyze the AI output, we have cases where book authors' rights have been violated because the AI output is creating text which violates rights of book authors, and we have about 7 or 8 cases filed by book authors. We have photographers filing cases because the output is reflecting the output of the photographers. We have privacy violations. The output is reflecting some personal data or privacy information, which then tells you that the AI system was not created using information of personal data. We have cases of hallucination and outputs. So we have different types of cases where in the infringement context, we have situation where people's rights are getting violated because their consent, whether it be for IPR rights, whether it be for privacy rights, was not taken at the time of training and developing these AI systems in the generative AI context. And one relevant aspect for your audience could be in this one relevant aspect for your audience could be in this is that the reason why so much data was taken was because since generative AI models, large language models, started developing in 2020 2021, it was predominantly around the use of large scale data. And as you kept feeding more data to the AI system, its ability to detect patterns and give outputs and generate text got better. So a lot of these data elements were taken to the system, which leads to these violations. And and I think the last point here is that to resolve this aspect, right? What would happen is that now companies have started entering into licensing agreements so that before they train the model, they take permission on a certain type of data. So that's the landscape. It's a fairly broad landscape on AI and IPR.
Yeah, understood. So to cover these all those things, we may have to have a couple of sessions. But it was really awesome and great content you told about. And since AI generates valuable intellectual property, what strategies companies can adopt to both secure ownership of their AI created IPs and develop successful business models to monetize those things?
Yeah, that's also a very good question. So I think there are a couple of things that companies need to look at when they're looking at AI. First, of course, is whether they need AI in the first place, because AI, not everything needs AI. just because you have large amounts of data doesn't mean that data is relevant for training an AI system. So I think there has to be a business objective that has to be met with AI, and then that has to kind of connect with the data that you may need to build an AI system, if you're looking to build an AI system. If you're on the other hand, and then there is the issue of where you're going to get the data, and then you're going to be looking at the aspects of data and building a model, and then you have to look into the various factors and the kind of technical skill that you may need to build an AI system. However, on the other hand, if you're looking to say build on top of a generative AI model, right, then is the issue of which model are you building on top of, what are the legal protections that you're getting when you license that particular model, when the manner in which you're going to use that model internally, who will have access to that model, how are you going to train the model, what data. So I think ownership on data is an important aspect, whether you build from scratch or whether you build on top of a generative model. The issue of IP is very important, whether how and what mechanism, when you have that data, what kind of IP protection are you looking at. Perhaps trade secret is a route for unstructured data, or you can get copyright protection. Then when you build an AI system, what sort of IP right you're going to need. In addition to that, I think there's the entire governance process that is to look at. So when you're developing an AI system, right, you there are ethical choices that you may make while developing an AI tool, or while fine tuning an AI tool. So something that captures your ethical choice in terms of ethical risk analysis or ethical choice committees, capturing your risk that may be there in a manner that is traceable. The traceability of data sets is also important, where you got the data from. Consent from various players is equally important. So there's algorithmic risk, there's ethical choice. If there's children's data involved, or if there's personal data involved, certain obligations come in there. Then of course the sector that you may be applying in, or you may be working in, then those financial, if supposing you're working in the financial sector, there might be certain separate regulations that may apply. So I think for companies, ownership on data, IP rights, even an overall structure in which they structure when they are developing an AI system, right, that would be very relevant. And when we are talking about monetizing it also, it is equally important to understand who will own the IP in what context. So these are very perhaps these are very broad questions that need to be answered in more factual circumstances, perhaps slightly. This is the broad picture, but we kind of have to sit down and understand very precisely what is being developed, why it is being developed, and what data is being used to develop it, to be able to provide more nuanced guidance. But of course, if we look at trends and the kind of manner in which uh, issues have arisen, the data collection, ownership on data, rights on data is very important. The IP rights, the consent aspect is important. The IP rights within the AI system is very important. Indemnities and how you protect yourself when you're developing on top of an AI system is equally important. And your use case and the impact, the manner in which you're looking to use an AI system, and the risk it may create for a particular individual, that also becomes important, because we don't have a formal risk classification. Perhaps in India the risk classification only exists in the EU, but a broad awareness of how what impact it may have is important. And the overall structure and mitigating your risk at each stage of an AI development is important. These are very broad strokes of what companies could do, but I think it requires a far more detailed discussion to sort of figure out a plan for a particular business.
Sure. Yeah. Uh, and Vibhav, can AI tools be used for tasks like legal research, contract analysis, or even generating legal documents? I would like to know about the role of AI in legal process currently. What kind of use cases you are doing with AI?
So yeah, so that's use of AI as a tool in legal practice. The short answer to that is yes, it could be used, but it depends. So the important point here is that you have to look at AI as augmenting human ability. And I'm going to emphasize the word augmenting human ability. Whether it be for contract review, you could train an AI system with standard template contracts to generate a particular contract, which could help you. Right, there are use cases in India where you are using AI in legal research. Even the Indian Supreme Court is involved in translation. There are some AI tools that are using, say, from translation from English to Malayalam. The vernacular, so translation of English into vernacular language is taking place through use of AI tools. So AI is definitely being used as a tool by different entities within the legal ecosystem, whether it be for research, whether it's for translation, or perhaps for live transcription also, where there is a in certain cases there is a live feed, and then the AI is doing live transcription during the court proceedings so that people can understand what is being said and what is being argued. Right, so AI is being used in that manner, but I think the use of AI in the legal space is predominantly as a tool to augment human ability. And that brings in a very important aspect, that when we are looking at AI, we also have to have this aspect of human oversight over its output. So if you're using AI even for contract review or for legal research, it also requires someone to review the output that an AI system has created, and so that we don't fall trapped into something known as automation bias. Right, it's just not just so that an AI system has created an output, you end up believing it in terms of it being the gospel truth. So you need to, of course, have humans involved, both perhaps in the training of AI system, and if you're at this end, to kind of overview and understand the landscape of AI systems, so that able to you are able to manage, and you're able to properly analyze the output that AI systems create.
Understood. So also I would like to know some tips for businesses developing AI systems, legal considerations and the best practices. What my end?
No
What I
worries.
was asking
Hmm.
is some tips for business developing AI systems. So what kind of legal considerations and best practices should they consider prioritizing and to ensure the responsible and ethical implementations of AI systems?
I think we've covered this in a little bit detail, but I can distill a couple of points. One is, of course, the ownership on data and the permission to use the data they're using to train an AI system. That's one. Right. Second is, while that may not be mandated by law, is having clear structures and processes called AI governance when you're developing AI within the organization clearly, so that perhaps you have algorithmic risk committees which capture the algorithmic risk or tracing of ethical choices that are made during the algorithm development, having a clear process in place when personal data is being used, and so that there is a certain level of traceability in these decisions. Third, as I indicated earlier, also is the fact that intellectual property rights, if intellectual property rights intersect with AI development in the development of an AI system, which relevant IPR we want to use. So there's data, there's internal structures, there are processes. If you're further fine tuning existing generative AI models and doing that in the context of for your organization, what kind of data do you need, how are you going to use it, are you going to do it internally only, are you going to do it externally facing consumers, how the particular business considerations that you have to do. So I think data, IPR structure, security mechanisms that you're going to put in place to protect the AI system. So I think there are various considerations that have to be kept in mind. These are the broad ones that have to be kept in mind, and we can further fine tune this further depending on which individual use case that arises. We've actually covered this
Hello?
question. Did hi. So I think, so no problem. I think we've covered this question. So I think start about the 52nd minute of the recording. We've covered this question of businesses earlier in terms of, so you can edit this part out. We've covered this when we spoke about IP rights, data rights, and all of that. So perhaps we can not repeat it, and perhaps we can leave the original answer. And if there's something else, I mean, I can what I can do is I can repeat those questions. I can repeat the answer one more time, and you can kind of figure out the thing, right? So let me just do that. So I think the factors a business obviously has to consider when they are either developing an AI system from scratch, or if they might be fine tuning an existing generative AI model, are considerations around data and the data that they and how they own it. Whether they have, if the personal data is being used, have they gotten the necessary consent? If they're using IPR protected data, do they have the necessary licenses? If there's public data there, then it's clear that it's public data and free to use. If other types of data is being used, whether there are no legal encumbrances in it, right? That's one aspect, which is data. Second, of course, is that when you're developing an AI system, or fine tuning it, say using a generative AI model, again, what are the intellectual property rights that you're looking to protect in that development process? What types of IP, trade secrets, contracts that you want to use? Three, if you are looking to build this, fine tune it hypothetically within your organization, what type of people will have access to that development? What mechanisms are you creating for a secure development, so that there aren't any breaches, and there isn't any data breaches? The people that you're working with, they have, hopefully they're contractually, as a developer or as someone who's fine tuning internally, you have necessary contracts in place, so that everything sort of is centralized to your control, in terms of there's no leakage of information. Then on top of that, I think there's a broad AI governance structure, right? If you're building an AI model, which market are you building it for, right? And are there any particular compliance requirements that that particular market may have, for which you might have to design your internal processes now itself? For example, if you're looking to launch in the EU, there is the requirement of high risk, low risk classification, and the risk classification of AI systems. So, if supposing you're intending to use your model for the EU market, then it'll be useful for you to now itself sort of figure out what type of rights, or what sort of impact your AI system may have, so that your internal structures can be figured out this way. This is, of course, just broad strokes. It'll require far more nuanced guidance and advice in terms of when you're developing an AI system, the kind of assistance that you may need.
Thank you, Ibo. So it was a great discussion I had today with you. I know we covered the basics of laws and all. So I may contact you for some more discussion so that we can go into detail on some specific topics and talk about them. So thank you very much for joining us. As a one last question, I would like to give you the time to give some takeaways from today's video to the audience who will be looking at this.
Right. Thank you. No, it's been absolutely my pleasure, and yes, we've covered a lot of areas in AI. I think the takeaways for this session, for anyone listening in, would be to understand what is AI from a non-technical perspective, and perhaps a simplistic understanding of difference between AI and generative AI. That's one key takeaway. Two would be perhaps, and less perhaps discussed, is how even to understand the legal aspects of AI, why one has to first understand the concept of AI ethics. So how, what is the connection between AI ethics and perhaps AI and law and the legal issues of AI? What are the different two facets of AI ethics? The ethical choice aspect and how society may look at it. Why perhaps AI regulation, perhaps India may not have a formal AI law. Why that may be a misnomer from my perspective, and what exists in the Indian AI regulation landscape. Another takeaway is perhaps the AI and IP landscape by itself, the components of an AI system and the different IP rights that may apply to an AI system, versus the entire debate on IP rights on AI outcomes and AI output, right? And I think finally, the entire aspect in terms of what businesses may do at a very broad level when they're looking at their AI journey, and then why that may then require slightly more nuanced guidance. So these are the various areas that we've covered, and people can we've covered a very broad stroke, and whatever might interest the listeners, they can tune in to the entire conversation, or they can take these specific aspects for their comprehension and for to get a bit create a macro understanding of AI.
Thank you, Iba. So, with the tight schedule you have, thank you. And this is a weekend also. I'm recording this. Thank you for your time.
Yeah.
Um, have a great weekend.
Thank you. Same to you. It's an absolute pleasure to be here, and I'm glad, and I hope this is going to be instructive for the audience. And I look forward to further conversations with you. Take care.
Yeah,
Bye
sure.
bye.
Thank you.
Thank you. Thanks.
Hope you enjoyed the conversation we had today. So, we try to cover the basics of AI into legal perspectives, how the rules and regulations are being made, how India has its policies, how uh, the real cases have been handled in US and China with examples. Also, what kind of monetization tips businesses should take, what kind of AI ethics are there, and what kind of development is going on, and about the IP laws, data protection, copyrights, and all resources. Um, those kind of different areas we have covered and given you the basics of it. So I know this one discussion cannot cover everything, so I'll be having a couple of discussions with the lawyers, legal bodies in the global, covering the global perspective, also who are into the expertise into this industry, and who are connected with global bodies, well recognized global bodies, and working for them. So stay tuned with me. And if you still haven't subscribed to my YouTube channel, I would like to invite you to subscribe. And if you have any questions regarding today's discussion, do comment on any platforms, or Vibhav will be definitely to joining for the future conversations. And there will be another several global leads, as I told you. Several lawyers will join with me, and I'm planning to do some live sessions. So those events will be announced soon as well, so that you can also join and ask your questions, raise your questions. So yeah, if you feel like this is good, do comment on the video as well. So it will be helpful for us to move forward. Thank you and have a nice day.